Ladies and gentlemen, welcome back to the beginning of the plenary sessions. Can I ask everyone here live in the Sydney Opera House to resume your seats? I'm afraid I have had to be rigorous with the 5-minute coffee break, so please bring your coffees back to the table. As I said, we move now to session 1, which is titled Investing in the Pacific, Promoting Confidence in International Business Through a Stable Disputes Regime. This is a roundtable with the international business and development community. Our moderator today is Damien Eastman. He's the Deputy General Counsel of the Asian Development Bank. And our speakers today, live in the Opera House, we have Lottie Schall-Siebel, who's the Regional Director, Pacific Liaison and Coordination Office of the Asian Development Bank. We have by Zoom Professor Dr. Jordi Paniagua, Professor of Economics at the University of Valencia. We have Mark Russell, Senior Commercial Officer for Australia and New Zealand at the US Department of Commerce. Thank you for joining us here. We have Craig Strong, Chief Executive Officer of Investment Fiji. We have Ram Bayakal, who is the Managing Director of FMF Foods Limited. And Chugwan Han, Director, International Dispute Settlement Division, Ministry of Justice, Republic of Korea. Damien, over to you.
Thank you very much, Daniel. Good morning, ladies and gentlemen, distinguished guests, to those of you who are gathered in Sydney and wherever you might be joining us remotely via Zoom and in whichever time zone you're in. My name is Damien Eastman. I'm the Deputy General Counsel at the Asian Development Bank, and I'm truly delighted to be joining you here today. And I'm honoured to have this opportunity to begin the technical part of today's third South Pacific International Arbitration Conference. Now, I see many of our colleagues who've been an integral part of our work at ADB in promoting effective dispute resolution frameworks. And I'm great and honoured to see that you're joining us here today. I am sorry I'm unable to join you in person, particularly given that Sydney is my hometown, and there's no better venue than the storied Opera House to convene a venue like this, and it fills my heart with joy looking at those lovely pictures of the Sydney Harbour Bridge and the Opera House immediately behind you. So as Daniel mentioned, our first discussion panel today will explore investing in the Pacific, promoting confidence in international business through stable dispute resolution regimes, which is a roundtable, a virtual roundtable with the international business and development community. Now that's quite a lot to get our heads around, but to help us through, we are joined by a panel of distinguished speakers. And Daniel has already taken a few moments to give you a short précis of their backgrounds and experience. And the conference brochure sort of contains much greater detail, on those who are joining us. So I am acutely conscious of the time we have allotted for this panel, because we have an austere 45 minutes for a topic that could itself be the subject of an entire conference. So with that, I have the pleasure of asking Professor Paniagua to start us off with a short presentation to set the scene for us. And we're going to hear from Professor Paniagua on his fascinating research, which shows the positive effect of international commercial arbitration and its benefits for economic activity and foreign direct investment. So over to you, Professor.
Hello. Good morning. Let me share my screen. So I cannot really share my screen, so I don't know if you want to share my slides, because I cannot share the screen now. It says that the function is not able to do it. Okay, now, perfect. So I hope that you are seeing my screen now. Let me just, okay. So, good morning, good night for me. It's past midnight here in Spain, but I'm truly delighted to be here. This is my third year in this exciting and really awesome conference. I would like to thank the organizers, especially Christina, Damien, and Daniel for having me here. And let's start, because we have a lot to cover in short amount of time, and just want to give you the outline of what we are going to speak today. Some economic trends, some really daunting trends, given the COVID situation. I want to share what has been the landscape for FDI and trade, and also how the economic mechanisms work. And I hope that I can convey the message that arbitration has been good for FDI, has been good for trade. But I want to share some novel research that we've been conducting with my estimated colleague Andrew Meisburg at the World Bank, where we have been looking at the welfare effects of arbitration. So that is GDP, consumer prices, producer prices, and this new research that I want to present today. This is the first time that I present this research in such a large and estimated audience, has been greatly inspired by my collaboration with the ADB, UNIDROIT, and our talks with colleagues. Okay, so this is the outlook of really what's behind FDI. This is the triad. FDI is not just money, no? FDI can be measured in jobs, which is the blue line. It can be measured in projects. So I want to take you just to what has happened, this missing part of the FDI in 2020. That's COVID. No? It's just daunting to see these figures. We have lost 1/3 of the FDI projects in just 1 year. No? So this is basically just daunting figures. How can we be sure that this is actually related to COVID? Well, we have to look at the monthly data. No? We can see here March and April how there was like this tremendous fall in FDI, both measured in capital terms, in projects, so factories not being constructed, but that's the real economic cost, no? What you cannot see, no? The opportunity cost that has been lost by COVID. And this is the figures in the whole world. So let's zoom into what has happened in the South Pacific. And we can see similar terms, if not bigger. No? We can see that more than 1/3 of the projects have been lost to comparable sizes. No, this is not just an illusion of this year. No, we can see the average projects, the average jobs. There has been a tremendous fall in international activity as it was expected. And we can see here also in the South Pacific that there has been a fall, and a fall has been sustained throughout the whole year. No? So after this really daunting figures, I want to show you what I think is the economic vaccine for this. No? So the economic vaccine for COVID would be, for example, international arbitration. No? Why? Because the data speaks by itself. No? We can see here in the research that I have been conducting, and also other researchers, that arbitration increases FDI, arbitration increases trade, and here we have the figures of what has arbitration done for welfare, for economic welfare in the whole world. No? So we can summarize that in a number. No? This is lucky number 13%. No? The GDP would have been 30% less today if we didn't have reasonable means of dispute mechanism for such trade. And also, this is not something which has been profited only firms or companies. So consumers have been benefit from it. So we actually have the stuff that we buy, the stuff that we import is 7% less due to the positive trade-induced effects of arbitration mechanisms. So this is a direct impact on consumers, but also producers have benefited from higher prices via selling their products abroad. So this is an important mechanism. So let me try to convince you to explain you how does this happen. This is the most important. So let's zoom in a little bit further. This is Australia. This is the Australian trading partners. This is the volume of trade. This is the distance to Australia. Australia is a very nice country. I hope I was there this year. So we can see that there is a negative relationship between distance and the volume of trade. So no surprise that New Zealand is the first trading partner, amongst the first trading partners with Australia, because it's really close. So what can you do to increase the trade with Australia? First, you can be bigger. No, you can be like the US, you can be like China. They are able to overcome this negative effect of distance. This will be the average. They are of the average, as you can see here, because they have a real economic mass. So this is the first thing. This is the obvious thing. If you are bigger, you're going to trade more. But then you can also be smarter. You can be smarter by sharing a common law with Australia. So you speak the same legal language, you speak the same economic language. And everybody can do that. Everybody can do that because we actually have a common law today, which is international arbitration. We can write a contract which specifies which law is going to apply in the contract, and that contract can be, if there is a dispute, it can be resolved in an independent court. This is by being smarter. So in today's world, you can really get closer to very far away destinations, not just by being big, but also by being smart. This is what we call in economic terms the gravity equation, which will describe this economic relationship between trading partners, between investment partners. And here you have the effect of economic size, and here you have the effect of frictions, which can be natural. We're speaking about COVID, distance, history, culture, but you also could have human-made frictions, which we can simply overcome with great work that has been done by these legal mechanisms and these legal bodies. So what is international arbitration? I guess I'm not going to steal time from my colleagues. They will explain you, but it's just this private dispute settlement mechanism, which is flexible, it's confidential, and it's final. It increases the trust between parties, and it reduces the uncertainty. But the motto of the conference was de-risking. This is basically just reducing the uncertainty because you can choose the law. Basically, this is the beauty of arbitration. And here, the results of our investigation, our recent research in joint work with the World Bank. You can see here there's an average of 13%, but there's also a huge heterogeneity. But you can see that even the countries that gain less, they have gained a bit. And if we turn to the countries which have ratified the new convention and those who doesn't, so the green dots are the countries who have ratified the new convention, most of the countries. The blue dots have not ratified, those are here. But you can see that even those countries who haven't ratified the New York Convention have benefited from this trade creation. Not as much of those countries, but the effects of arbitration has spilled over the whole world. And I want just to focus here on the South Pacific. This is approximately 11 percentage points of GDP increase just by sending a signal, like my former speaker friend said, when Timor-Leste joined, it's sending a signal that it's open for business. And it's also interesting that these figures are a little bit larger than the most developed countries like the OECD, which is, on average, it has been positive, but it has been less than the world's average. So it's benefiting not only advanced economies, but also developing a real interesting benefit. We can see here the consumer prices. When consumer prices go down, we have more money in our pockets, so that's positive for everyone. And again, we see the same pattern. Where has the consumer prices decreased the most? In the green dots, which are those countries who have joined the New York Convention. Also here, for example, we can check the South Pacific consumer price exchange. They are down by 5%. So basically, if we didn't have these dispute mechanisms, the products and services that we buy that will be 5%, will have increased by 5%. And here we can see also the producer prices have increased. That's positive for companies because they can sell their products at a higher price abroad. So the benefits. So this is basically economics 101. Why does the GDP increase? Consumers buy their products at a lower price, and the companies can find other countries where they are willing to pay a higher price for their products. And just in a nutshell, what can we do to promote international business through these kind of mechanisms? We can do the traditional way, get closer, grow bigger, but we can also be smarter and especially in these days, we have to be healthy and safe. No, it's not until we resolve this global pandemics until these mechanisms will take traction. So thank you very much. I think I stick to the time.
Thank you very much, Professor Paniagua. That's whenever you're speaking to a community of lawyers, of course, sort of evidence is key, and I think it's just fascinating to see you're able to distill the sort of key outcomes of your research, and just to sort of see quite clearly the positive impact that that the accession to the New York Convention has on GDP outcomes. I think it's just really fascinating. So thank you very much for sharing your research with us. So given that we are focusing here on promoting confidence in international business, what I would like to do is to bring in Mr. Mark Russell, who, as Daniel introduced, is the Senior Commercial Officer for Australia and New Zealand with the US Department of Commerce. And Mark, I'd like to bring you in, and I'd really welcome your insights and thoughts on, in your experience, what factors do foreign investors look for when they're deciding to invest in foreign countries, but particularly in the South Pacific region? I'd be very grateful if you could share some of your thoughts and insights with the participants. Thanks.
Well, thank you. Again, thank you for having me here today. I appreciate the opportunity to speak. Again, my name is Mark Russell. I'm the Senior Commercial Officer for Australia and New Zealand. What that means, basically, I'm not an attorney, but I'm a diplomat, and I didn't come from Washington, D.C. I just came from a MLC center just down the street, so it wasn't too far a commute. I've been stationed. This is my 6th overseas posting, and what, in my experience, what U.S. companies and other foreign companies are looking for when they're investing, or looking to invest abroad. I would say there's U.S. companies and other companies. They have a limited amount of capital that they can invest overseas, and so the more attractive a country can make themselves as far as investment, the more likely they're going to attract the international funds, because it's a competition. Countries are competing against each other. The Pacific Islands are going to be competing against other Pacific Islands. When I was in Brazil and India and other places, Brazil was competing against Argentina and so forth. And generally, besides the market and market opportunity and being a market for the product that the company represents, there's some general basic ideas that companies look for when they're investing abroad. And most of you've heard it a little bit already. Of course, rule of law, ease of doing business, ease of starting a business, contract enforcement. These are all some basic things that companies look for. Dispute resolution. Is there a mechanism to that companies can go to for contract issues or contract disputes? Also, no company wants to go into a lengthy court case. That's especially for a small, medium-sized company, that they can't afford it. They don't have the time, and in most cases, they'll just either depart the market or just give up. So, lengthy court cases, nothing everybody wants to see. The idea of international arbitration, yes, it's something. If that's a mechanism that countries use, it is definitely an attractive bullet point for countries to highlight when they're trying to attract investment, because obviously it's efficient, it expedites the process, and it's definitely an issue that countries are looking for. Because ultimately, all these things I just talked about encourages or increases economic growth, and the more economic growth, the more opportunity the country's going to have. And if a country doesn't have the things I talked about, then the companies kind of look at risk versus reward. Some companies might not have, might have issues with intellectual property rights, but the market size might be worth the risk that they're going to go ahead and go into it. So that's the model that the companies have to look at, the risk versus reward. But in general, backing up the rule of law, dispute resolution, contract settlement, ease of doing business, expedited legal system. These are all things that are check boxes that companies are going to check when they're looking for foreign investment.
Thank you very much, Mark. Can we just, if I can just take up the risk versus reward point, I think that's a very interesting issue that you raised. Are you able to just sort of unpack that just a little bit more for us?
Sure. For when I was in India for a few years, and of course at the time India was transitioning. And some might say that India is a difficult market to work in, but the reward was the market size and the future potential sales and benefit that the company would have for operating in India. So, and again, back to the Pacific Islands, it's really going to come down to the individual company, their perspective as far as is the market opportunity there, and is it going to be? Do they see a potential growth that even if even if there are some risk, the market opportunities will overcome that. It's worth the risk to still go into that market.
Terrific. Thank you very much, Mark. Let's now move to Changwan Han, to Director Han, who is going to give us some insights into how international arbitration has contributed to economic activities and investment flows in South Korea. And I think this will be a particularly sort of interesting insight in the context of this panel. So perhaps I can ask you, Director Han, to share your thoughts and insights with us.
Okay, thank you for the floor, and thank you for having me today. As I do not have much time, I'll get to the point. Okay, I'll share my screen first. Okay, as Professor Paniagua and Mr. Russell eloquently pointed out, a stable and effective dispute resolution system can play an important role in promoting sustained economic growth and attracting foreign direct investment. I just want to talk a little bit about Korea's experience in this regard. Actually, after the financial crisis in 1997, South Korea wanted to develop dispute resolution processes in order to establish more cost-effective and quicker alternatives to traditional court system. First of all, in order to prevent dispute and resolve grievances of foreign invested companies operating in Korea, foreign investment ombudsman system was established in 1999. All foreign investors can use the foreign investment ombudsman system. The entire grievance resolution process, including consultation and assistance, is free. Right? And also in 1999, Korea revised the Korean Arbitration Act in order to substantially adopt the Unilateral model law on international commercial arbitration. Korea became the first country in Asia to adopt the Unilateral model law. As you may know, the Unilateral model law put forward legislative provisions to harmonize national laws worldwide. Most notably, this includes limitations upon the extent to which a court intervenes in arbitral proceeding and set aside an arbitral agreement or arbitral award. And once again, in 2016, Korea also revised the Arbitration Act to implement international best practice standards incorporated under the 2006 revision of the Unilateral model law. In 2017, Korean Arbitration Industry Promotion Act came into effect. This act includes provisions to expand dispute resolution facilities, to cultivate experts and professionals in the area of arbitration, and to support research and development in the field of arbitration. Also, in order to establish reliable international arbitration practices in Korea, KCAB International was launched in 2018. Since then, KCAB has been able to enhance its general reputation, the level of professionalism of staff, predictability in case administration practice, and quality and diversity in each arbitrator pool. Since then, KCAB International has helped to grow arbitration industry in Korea. As you can see here on the screen, the number of arbitration cases has increased every year since the launch of KCAB International. Okay. We also have court on conciliation and mediation. Korea is also one of the countries which signed the Singapore Mediation Convention in 2019 because the Singapore Convention can play an important role in facilitating international commerce and provide greater assurance for businesses. South Korea is now putting in the effort to adopt and implement the convention into our domestic system. As you can see on the screen as well, we have various kinds of specialized resolution processes as well. Alternative dispute resolution system, including arbitration, South Korea had adopted and developed so far, as I mentioned earlier, has provided speed, convenience, comparatively low cost, and consensual resolution, and many other benefits. As you can see here on the screen, according to the World Bank Doing Business Report 2020, South Korea is now ranked 5th among 190 economies in the ease of doing business, especially the second in terms of enforcing contract, and the 11th when it comes to resolving insolvency. So this may show that effective legal framework, including arbitration, can improve business environment in domestic setting. Okay, I think this was my observation on this issue. Thanks.
Thank you very much, Director Han. Let me now move to bring in Craig Strong, if I can. And so, as Daniel had introduced, Craig is the Chief Executive Officer for Investment Fiji. And Craig, I'm just fascinated to bring you in and to ask you, what's Fiji doing to make doing business easier in your jurisdiction, and what are you seeing in terms of the positive trajectory for Fiji, having regard to the various reforms that Fiji has sort of brought into place in the past few years? Over to you, Craig.
Vinaka, Damien, and good Vinaka, everybody from Suva. Particularly, I'd like to acknowledge the speakers that have gone before me, but with respect and acknowledging the welcome to country. So thank you, and Vinaka. And thank you for the introduction, Damien. And that's really what I wanted to talk about today, was in the Fiji context. 4 key areas: the investment reforms, our transition from an organisation to purely a trade and investment promotion agency, the dispute resolution provisions in the draft investment bill, and notwithstanding that, Fiji ratified the New York Convention in 2010 and then enacted the Fiji International Arbitration Act in 2017. And noting that our Solicitor General will be talking in the next plenary, I'll probably leave him to do some deeper dive on that. But again, just following on for your question, in terms of the investment reforms, Fiji's really rolled up his sleeve and taken a pragmatic approach in driving investment reforms, particularly in the context of trying to increase the ease of doing business. So since 2017, the Fijian government has compiled, with the assistance of the World Bank and the IFC, a legal reform package. And the first and the most probably the foremost I'd like to discuss quickly is the investment bill. And so the investment bill was read in our Parliament in the House in December of 2020. And that will essentially replace the Foreign Investment Act of 1999. Now, the Act aims to really achieve 5 key things. The first is to contribute to an attractive investment climate in Fiji, to increase not only foreign but also domestic investment, to generate employment, to contribute to sustainable and social development, and also to promote growth for the benefit of all Fijians. Importantly, the bill seeks to strengthen 5 fundamental principles that is believed is important for the attraction, retention, and growth of investment here in Fiji. The first is clarity. And the bill provides key definitions and provisions that are in line with international best practice. In terms of transparency, 3 is openness and predictability. And a fundamental change to is that the current Act, the Foreign Investment Registration Certificate, which we administer as an organisation. So we've had pretty much a regulatory function as well as a trade promotion function since our establishment in the early 1980s. So this is quite a major change for our organisation and for foreign investors. So if you come to Fiji as a foreign investor, once this bill is enacted, you don't come to Investment Fiji and apply for a foreign investment registration certificate. You will go just to our registrar of companies, get your certificate of incorporation, and then with the assistance of Investment Fiji and our investment sector officers, we can navigate you on the process of approvals through the competent authorities. Fourthly, which is equally important, is basic investor rights, and that's a core part of the bill, to guarantee investor rights. And finally, the legal recourse and the enforcement of rights. So those are the key kind of elements to the bill. And so it is a time where we're transitioning. It is a time where we're showing that we are being very pragmatic, ensuring that we really grow that framework for investor confidence here in Fiji. So in terms of how do we bring this to life, obviously with our organisation, as I've just explained, our role is changing. So we are now migrating from a bit of promotion and a regulatory authority into purely a trade and investment promotion agency. And thus, we'll be pretty much judged on 2 things: the trade revenue that we deliver for Fiji and the investment outcome. So, our interest in the regulatory framework is obviously very heightened at this stage. One of the things in terms of our strategic reset, and obviously dovetailing into these regulatory reforms, is as an organisation and as a country, given COVID, as we move from recovery to sustainability, is working on a revised strategy. And what we are in the process of doing is we're in the process of very comprehensive consultations with all industry associations in Fiji in the development of a strategic plan in terms of what are the key investment sectors that Fiji will target to grow over the next decade or so. And so we're coming together to workshop this at the end of March. So we're very confident that once we have that kind of front end idea of which the investment sectors that we will target as a country, back-ended by the regulatory reforms and a good capability strategy for our organisation, that we can get to where we need to go. And obviously the 3 key areas that we will focus on in terms of keeping our customers, our investors, whether they be foreign investors or domestic investors, and our exporters at the heart of what we do and the delivery of services. I just want to touch on in terms of what we're looking at doing here is in terms of our investor projects team. So once we get through the strategic planning process and identify these are the key sectors of interest that we'd like to drive, we will then back-end that with capability within our office here of specific investment sector project managers. So, for example, there may be one for the digital economy. There may be one for manufacturing. There may be one for tourism. And so when we bring investors from overseas, whether we're matching financial capital or technical capital or a wholesome investment, that then gets passed on to that particular sector manager whose key role is to make sure that they operationalize that investment, to navigate through the approvals process and to minimize the cash burn. So we're really making sure that from an operational perspective, we can bring the regulatory framework to life and to grow investment in Fiji. In terms of the investment bill, there's Part 5, Section 19 talks about dispute resolution, and Section 20, the right to arbitration. So those are critical parts of the bill. But just finally, what I wanted to close with is that I think what Fiji is showing that there's a massive appetite at the moment for making it easier for investors, both foreign and domestic. Like Timor-Leste, we're open for business, and arguably after 350 odd days of being COVID-free in terms of community cases, we're ready. So we're looking forward to borders opening, but we are match ready to grow investment in the region. I think proven by the reforms that are taking place that we're standing in good stead to be able to do that. So I'll probably leave it there, Damien, and happy to explore anything that you'd like to ask further. Punaka.
Thank you very much. Thank you very much, Craig. Look, I think now that we've heard from the sort of academic perspective, we've now heard a number of countries' perspectives. I'd now, if I could, I'd like to bring in Ram Bajakel. And Ram is the managing director of the FMF Foods Group, who's also joining us from Fiji today. So good morning, Ram. And I'm very keen to sort of now move sort of into understanding a little bit more about, as a private sector player in the region, I'd really like to hear your insights and perspectives on why international arbitration is good for your business. And I'd welcome sort of your thoughts and insights on that. Over to you, Ram.
Sure. Thank you, Damien, Bula, everybody, and greetings from this beautiful island country of Fiji. As a small island country and particularly as a nation that, I think this is true for most Pacific Island countries, we are very dependent on external trade and external relations. So when you look at typically imports and exports as a percentage of our GDP, most of our countries are in the range of between 50 to 70% of our GDP. Imports is that much, and about exports accounts for about 50% of our GDP as well. So that shows us the extent of external dependence on trade. And therefore, by definition, what this means is a necessity to do business with many, many entities across different countries. Now, this compares with something like, if you take the economies of China, US, India, typically they would only be about 15 to 20% dependent on exports and imports. So for us, by definition, we need to trade in partnership with a lot of other countries. And this means that, this could be in the form of distribution arrangements, it could be in the form of joint ventures, it could be in the form of technical collaboration assistance, it could be in the form of royalties that we might be paying for use of certain licenses, franchise, technologies, and all of these have partnerships. Now, when we do this with multiple countries across multiple jurisdictions, there's always arguments about which jurisdiction we need to comply with, or which sort of laws we comply with, and having to deal with these sort of things entails a very high cost and also the kind of legal expertise that we may not necessarily have. So this requires us, I think, to recognize that when we have disputes with partners, which are again inevitable, we need some dispute resolution mechanism that is swift, that allows us to move on very quickly, which is neutral and doesn't require us to kind of have to know the laws of multitude of countries. We always try and remind ourselves that we are here to do business. We are not here to litigate. That's not our primary focus. And we definitely want to be spending more time in the marketplace, in our factories, with our customers, rather than spending it in the corridors of the judicial system. So I think that's why international arbitration is very, very good for us. It's something that we look forward to. And in terms of why it's attractive, the first thing that we really look at is, I think it gives us some clarity in terms of the choice of arbitrator. Sometimes that's very difficult to negotiate amongst parties and it's happened to us in 2010 when we had a dispute that we were seeking to resolve, we first went through a process of mediation. Mind you, that would actually be the first thing that we would love. But if we don't get past resolution in mediation, arbitration would be the next. We actually struggled to even agree and settle on an arbitrator, and the whole thing hung because it took us months to try and negotiate between the parties about who was going to be the arbitrator. Luckily, wiser sense prevailed, and both parties agreed to resolve the dispute on our own rather than take it to arbitration. But if it were, then I think a mechanism like this gives us a place where we can get neutral arbitrators, and these would be, again, subject matter experts, with no disrespect to the legal professionals in this forum. I think sometimes when you have subject matter experts, they are able to see the finer side of the business things and are able to resolve the issue much faster. Undoubtedly, cost is a major factor that we would look at about why arbitration would help, because it's not only much quicker, it costs us much less as well. And another attractive feature is the fact that it's definitive and binding. I think when it's binding, you know that it's not going to go into an appellate process, and it's not going to get protracted and delayed. So I think that's something that we really, find very attractive. There's the enforceability. That's something that's again very attractive, because we've had one particular instance where we got into a legal dispute in 2009. We're in 2021 and we still haven't resolved that. It's been going on. In 2017, there was a settlement. The parties agreed to settle it, and then they went back on their word. So 2021, 4 years later, we're still trying to get that enforced. Now, these sort of things with an international arbitration and the enforcement mechanism, once the countries pass it into law, I think there's a far higher, possibility of resolving these things much faster than present mechanisms. I think another very key issue here with arbitration is the confidentiality of the arbitration processes, because what happens when it's literally like, quite often like a family dispute that very quickly gets resolved, and you're able to continue doing business together rather than it being made public in the courts. The whole thing comes out and the egos of the parties kick in, and after that they're reluctant to do business with each other. So I think when it's confidential, you very easily get past it and you're able to resume business, as happened to us in that first 2010 case that I mentioned, although it was not arbitration. The fact that it didn't get into legal proceedings meant that we were able to do business for almost 4 years thereafter without any issues whatsoever. So I think these are some of the things that we find very attractive in the arbitration processes. Thank you, Damien.
Very good. Thank you so much, Ram. Very much appreciate your insights and what arbitration means and the effective role it plays for you. Let me now turn to my dear colleague Lotte Jou-Sebel. And Lotte, perhaps as we sort of bring all of this together, as we've sort of heard from our various contributors, perhaps I could ask you just to sort of for you to share your insights and thoughts on how you see foreign direct investment as a tool for the Pacific economies to spur their own economic growth, and what ADB is doing to contribute to those efforts. Lotte?
Thank you, Damien, and it's a great pleasure to be here, and it's nice to be here in person too. And also appreciate to listen to my fellow colleagues here on the panel. I'll pick up a few of these comments in my notes as well. But just to start off with, I think to me foreign direct investment provides a very important tool for Pacific governments to consider when they're developing their economies and to promote further growth, and also to attract foreign direct investment. And of course, arbitration has positive and significant impact on attracting foreign direct investment. And I also like to mention that there are a lot of, as Jordi mentioned, there are many positive effects of FDI, and these include skills, technology transfer, employment, increased access to capital, economic diversification, and also improved standards of domestic or of corporate governance. But of course, many of these, foreign direct investment is not always well realized in many countries, including in the Pacific. And one contributing factor to this are weak business enabling environments. And these can lead to increased costs, reduced productivity, and also increased policies that can hamper foreign direct investment. And at ADB, we have as a core mandate to promote a prosperous, inclusive, and sustainable Asia-Pacific, and including to eradicate extreme poverty. And with this in mind, more and more responsible and well-managed foreign direct investment is something that we emphasize in our pursuit of this mandate. And we have several different avenues for addressing this. We have the public sector window, our public sector operations, where we provide policy and implementation support to countries, including in the Pacific. And this includes support to strengthen business environments and improve domestic competition. So, for example, this includes legal and regulatory reform, support to micro, small, medium enterprises, domestic resource mobilization, tax reforms, capital market development. And then we have our private sector window, our private sector operations, which crowd in private finance in the region. And examples include equity investments in, for example, Kina Bank in Papua New Guinea, Fiji Airways, targeted support to telecommunications and renewable energy across the region. And then we have a number of other initiatives, including the Private Sector Development Initiative that was also pointed out by our counsel, Tom Clark, earlier. And this is co-funded by Australia and New Zealand. And they provide really important support in foreign investment laws, credit registries, and they're also currently undertaking an important study on foreign direct investment, and this will be completed in the second half of this year. And this will also allow institutions in countries that are participating in this study to better understand how their institutions align with best practices to attract foreign direct investment. And I think more generally, given that many countries in the Pacific are now managing increasing debt burdens, I think this is a great opportunity also to promote more private sector solutions to support economic development. Thank you, Damien.
Thank you very much, Lotte. Now, I'm just looking at my clock, and we've already sort of reached time. So I think let me take this opportunity to sort of thank our panelists this morning. I mean, this has really been a sort of fascinating discussion. It's always wonderful to sort of hear Professor Jordi's research, and also to hear the insights from those who advise others with respect to foreign investment activities, hearing the country perspectives, and also hearing from RAM as to sort of how international arbitration framework directly benefits his business, and also from Lotte to hear sort of what ADB is doing to promote foreign direct investment in the region. So with that, if I could ask you to join me in thanking Professor Jordi, Mark, Changwan, Craig, Ram, and Lotte. Thank you so much for your time. We really deeply appreciate the time and effort that you've gone to be with us today and to share your insights. And with that, Daniel, I'll hand back to you.
Damien and all panelists, thank you very much for that incredibly informative plenary session. We thank you for your time. We thank particularly Jordi for staying up till midnight in Valencia. And we'll now move to have a short break before we move to session number 2 so that can be organised. We are only slightly over time, so we've actually got a whole 10 minutes for this coffee break. So relax and enjoy. And we'll reconvene at 1:15 for session number 2. Thank you.